the UK Supreme Court came out with one clear direction, and they say that Section 7 and Section 13 of the Act could only be interpreted one way, and that is inventor must be a human being. Inventor must be a natural person. And in this case, the boss being an AI, which is not a human, can never be named as inventor because of how the act is being drafted.
You're listening to the Legal Insight podcast by HHQ, where we help you unpack the world of law, business, and tech. Today, we're going to deep dive into our recent article titled Exploring the Legal Implications of AI as Inventors, UK Patent Law Perspective. Artificial intelligence can do everything. Well, except for inventing things. At least this is according to one of the cases that we're going to unpack today. Maybe Johnson, you can kick us off by just giving us a brief background of what we're going to explore today. What is the case that we want to look into regarding this issue?
So today, we actually want to discuss whether AI could ever be named as an inventor. So why is this question that important? Because recently I was actually being invited to be a speaker in one of the AI conferences. So in the discussion, I was speaking to many different speakers, and I was actually informed that a lot of companies, be it tech companies, manufacturing companies, they are heavily relying on AI technology for their innovations. And one of the key questions that many companies may not have considered is ultimately whether the innovation that is being created by AI technology could be protected under patent law. So today, I think that we would like to look into UK patent law perspective in understanding whether an innovation that is being created by AI, solely AI, could ever receive this kind of patent protection. And lucky or not, this is actually not an academic discussion because last December, the UK Supreme Court has actually made a clear finding of these decisions in determining whether AI could ever be named as an inventor. I mean, I don't think that we want to disclose the answer first. I think that it's very important for us to understand the context.
Yeah.
So usually when any companies or any parties, before they want to do a patent filing, the first thing that they have to do is to name an inventor. You need to know who is the one created that particular innovation. So how about a situation or a scenario where the particular invention is solely created by AI alone, is created by AI autonomously without human involvement?
Yeah.
In other words, most of the time from our understanding is that a company would leverage on AI as a tool to innovate. How about a company without giving an instruction to the AI, whereas the AI just innovate as such? So in that case, can AI ever be named as an inventor? So I think that this is a question that we have to look into. And what happened is in UK, a scientist actually have filed 2 patent applications. The scientist is actually called Dr. Taylor. So in that particular case, Dr. Taylor actually make 2 patent applications, 2 patent filing. And then what is really special about this case is he did not name any human inventor for the applications. In fact, he claimed that 2 innovations is actually created by AI machine that's owned by him. I don't know how am I supposed to pronounce the AI machine, but it's DABUS, Dabus, Dabus.
The bus.
The bus. Okay, I like that. So the bus. So what happened is he said that the AI machine is owned by him. The bus is the sole inventor of the innovations. And then he said that, so in this case, the bus should be the inventor, and since he is the owner of the bus, so he should receive the patent protections. So the court actually looked into the case, and the court eventually make a finding of whether the bus can ever be named as an inventor for the 2 particular innovations.
So I'm just curious about the case. And let's talk a bit more about the case before we dive in deeper, right? Like, I'm just curious about Dr. Taylor's intention here. Like, why did he do this? Why was this case brought to the court in the first place?
So basically, until today, we do not have any concrete evidence whether the particular innovation is created by the bus alone. At least that's what he claimed.
Yeah.
He claimed that this innovation is created by the bus, his AI machines. So in fact, if you do a general Google search, you'll be seeing that he has found plenty of patent application, not only in UK, but all over the world. I think the reason that he is doing so is not so much to actually receive the patent protection, but he is trying to push the boundary of AI and also our intellectual property law. He actually wanted to know. So in the future, what if AI really has the ability to actually innovate? In that case, is our law sufficient enough to actually keep pace with the technological progress?
Yeah.
So I think that this is more than just a creation for him to protect his innovation, but this is also his way of actually trying to understand the legal progress from different jurisdictions and different countries.
Interesting. So Khai, maybe you can let us know, like, what are the key questions or key issues that were explored in this case?
Yeah, sure. So I think first of all, we need to have a disclaimer in a sense that our discussion today is not so much, or rather the case that has been adjudicated in UK, right? It's not so much on whether AI is capable of creating inventions, whether the whatever output that is generated through the use of an AI would fulfill the patentability requirements, right? It's really not so much about that. And because of how Dr. Taylor has submitted his patent applications and how he has put forth his argument in court, really the purpose, if I may put myself in the shoes of Dr. Taylor, is like what Johnson has shared just now, to test the boundary of existing patent legislations and see whether what we have currently can accommodate a scenario where AI could potentially create inventions. So that's the context, right?
Yeah.
And the particular case that Johnson has brought up, inventions created by the bus.
Let's go with the bus.
Yeah, let's go with the bus. Let's go with the bus. So that particular case primarily focus on two areas. Number one, can an invention created by, or rather, let me rephrase it differently. Can the bus, being an AI, be designated as an inventor, right, when it comes to submitting of patent applications? Number two, assuming that yes, an AI can be considered as an inventor, or rather, if AI cannot be considered as an inventor, can the owner of the AI then derive some sort of rights or ownerships over the inventions created by the AI and then subsequently claim ownership of the patent over the inventions? The second part of the questions, you can think of it very similar to a case where a company, for example, would naturally derive ownership over employees' creations or employees' inventions through operations of law. So can this analogy be applied to an event where whatever invention that is created by an AI, for example, would be automatically transferred, the ownership itself be transferred and be vested in the owner of the AI machine or the user or operator of the AI machine? So these are the questions that have been explored by the UK case.
Yeah. So I'm just going to go right into it. What was the UK Supreme Court's decision on whether AI can be an inventor?
The UK Supreme Court actually looked at Section 7 and Section 13 of the Patents Act 1977. And by looking at it, the UK Supreme Court came out with one clear direction. And they say that Section 7 and Section 13 of the Act could only be interpreted one way. And that is, inventor must be a human being. Inventor must be a natural person. And in this case, the bus being an AI, which is not a human, can never be named as inventor because of how the Act is being drafted.
So the Act that was drafted in 1977 is actually giving us direction today in 2024 who can be an inventor.
Yes, correct. So basically, based on the Act itself, they make it very clear, if you want to be an inventor, you have to be a human. You need to have blood. You need to have a soul. If you are just an AI, if you are just being operated by neural networks, unfortunately, you are not human. Or at least until now, the law will not recognize you as a human, as a natural person. You will never be named as inventor under UK context.
Right. So of course, I don't know whether that drafting itself at that point in time, whether it's intentional or unintentional to exclude AI, right? That's something that we will never know.
I think in 1977 there were already computers, there were already, machines
some level.
that could some level, right?
Yes.
Since Alan Turing's time, you have things that can produce numbers, that can produce things. But I'm sure this current iteration of AI is not envisioned back then.
Yes.
So what about the second question regarding the owner of this AI machine, deriving some sort of rights to those created by that AI?
Yeah. So in that particular UK case, the answer to this question was that because there is a requirement for an inventor to be a natural person, right? And it fails the patent applications filed by Dr. Taylor, designating the boss as the inventor. It failed at that level, right? The inventor requirement wasn't actually fulfilled. So naturally, as the owner of the machine or the operator of the machine, the owner of the bus in this case, could not derive any form of rights or ownership to the invention created by this non-natural person inventor.
Yep.
So the answer to the second question is no as well. Dr. Taylor could not receive any form of protections over the patent or rather any form of ownership over the invention created by the bus.
Okay, that's surprising to me. What are the implications here? Like, what can someone in Dr. Taylor's shoe do to actually circumvent this or to actually gain some rights from this?
So I believe that on this issue, some of the thought leaders looking at this case actually say that it could have made a difference, assuming that Dr. Taylor, instead of designating the bus as the inventor, he just makes himself as the inventor, just claim inventorship, right, over the inventions that has been generated by the bus.
Yep.
Because ultimately, someone has to key in a prompt,
Yep.
right? It could be Dr. Taylor. So on this note as well, if Dr. Taylor is not the person that is inputting the prompt to the generative AI, to the machine or whatever, allowing the machine to create the invention, then perhaps that person could have been named as the inventor. Or a third option is whoever that has created the machine, program the AI model, could perhaps be named as the inventor instead, right? So these are the few permutations that we have not seen anybody explore yet. Dr. Taylor consciously and intentionally chose not to use any of these methods.
Yep.
So we don't know what would have been the outcome.
Yeah, that wasn't the intention anyway.
Correct.
Yeah.
Yes, correct. So just to add on, so basically, if you actually read through the judgment, the UK Supreme Court actually make a very important remark. The Supreme Court actually make it clear by saying that in these applications, if the bus is actually being used as a tool, instead of saying that the bus is the machine who created this innovation without any control, without any human involvement, the outcome will be different. So basically, the court is actually implying, saying that, look, AI at this moment is not able to generate any invention without human control. But if human has leveraged on AI technology as a tool itself to generate any particular innovations, there is possibility for any particular inventions to receive patent protection.
Okay, so Johnson, what I'm hearing is that if there is some form of human oversight or human intervention over this invention, this person could then derive a certain right towards the creation by this machine.
Based on what we are seeing, in the event where a particular innovation is solely created by AI autonomously, it means that without any human involvement, without any human control, or without any human interference, it is not possible for the AI to be named as inventor. It is not possible for that particular innovation to receive patent protections. But based on the remark actually made in the UK Supreme Court, the court actually make a small remark by saying that in the event where AI is actually being leveraged as a tool per se it means that there is certain degree of human involvement, human control in using AI to create that innovation, the outcome will be different. So right now, I think that as a best guideline that we all can fall back to is just do not solely rely on AI to create any particular innovation autonomously. There should be certain degree of human involvement, human oversight, or human control.
Yep.
That is the only way for anyone to potentially obtain any particular patent protection.
That's obviously a pretty crucial distinction, right? Human intervention versus a fully autonomous AI creating something. So given that this is the position of the law right now, according to the UK Supreme Court, right? What do you see, Khai Yi, as the broader implications to this decision? And is there any recommendations to companies or individuals who are actually already leveraging on AI to create new inventions or new innovations?
Yep. So I do see two implications per se, or two key takeaways from that particular UK case.
Mm-hmm.
The first being our law is still very much uncertain when it comes to treatment of AI-generated work. Whether an invention created by an AI, for example, can really fully suffice or rather fulfill the patentability requirements under the Act, whether from a technical standpoint or whether from a formality standpoint, right? Because I don't think that the inventorship requirement, I don't see it as a substantial requirement, but more of formality requirement. So at that level, it doesn't seem like our Act has caught up with the advancement of technology, the advancement of AI in this case. So first and foremost, I think that there needs to be some certainty. Whether that should take the form of an amendment to existing patent legislations, or it can be done via some form of guidelines or rather some form of practice directions given by the intellectual property offices all around the world, right? We need to come to an agreement on whether AI-generated work is patentable or not, and even perhaps whether an AI can be named or rather be included as an inventor. The second key takeaway is, given that there's still no certainty, so companies leveraging AI in their day-to-day operations in circumstances where inventions or rather inventors, people involved in the R&D of a product, for example, R&D of processes or inventions in companies, should really be mindful of the usage of AI in their day-to-day work. And companies should again work with legal experts to maybe formulate a set of internal guidelines to really steer or align the usage of artificial intelligence by the employees in their creative work, in their R&D work, so that the level of usage of AI, if any, can be controlled, right? So that there's never an argument to say that a particular invention was created with very minimal human input or very minimal human involvement. Yep.
I just want to add on. So basically, I think that just now Khai Yi, he brought up a very, very good point.
Yep.
So eventually, I think that laws would definitely need to be updated. At this moment, we may find it difficult for us to imagine how is it possible for AI model to generate, to create an invention autonomously. But one day, this day will come. One day, technology will eventually catch up, and technology will eventually be able to generate, to create something autonomously without human control, without human involvement. So when that day happened, is our law ready to catch up to the technology? I think that this is one particular important question that every country, that all legislators should pay particular attention to.
All right. So I guess until then, most of our jobs are still secure. And, we can't fully be replaced by AI. So I can take some comfort there, even though, we want to see more innovation and we want to see the law actually taking a more proactive approach towards these innovations because they are lightning fast. Like it's just going.
I mean, there are always two sides to the same coin, right? Mm-hmm. So imagine that you are a company investing a lot in AI.
Yep.
Are you willing to push that hard? Because knowing that if that technology that I invested in will not be able to receive the protections. So am I supposed to actually invest the amount of energy resources to it? So this will somewhat discourage AI adoption and also slow down innovation to a certain extent, because the companies, they will not be willing to invest if law is not up to date to protect the innovation that is created by AI. So there's always two sides to the story.
That's good insight. Thank you, Johnson and Khai. I think that's all the time we have for today. If you found this content helpful, please show your support by reviewing us on Spotify, Apple Podcasts, and also YouTube, wherever you're listening. This will help us reach a wider audience. Tune in next episode for more thought-provoking discussions on law, business, and tech.